Hello. I'm only mentioning SG is also there.
Ma'am, possibly the combination is not available tomorrow.
Who may
It's
not
a three-judge matter.
Just send me a letter or an email. I'll see what can be done.
If it can be listed next Wednesday, that's the only small request.
So there may be some changes from Tuesday onwards. We'll let you know about it. There may be some changes, but we'll try and accomplish. How long will it take?
It will now end in about 2 hours.
We'll see how quickly.
That's all.
It can be one session or something. That's all.
Request and by email.
We shall do.
All mentionings to be sent by email or via written letter. No written or oral mentionings in the format.
In one case, I am asking only not to be deleted.
Right.
That
just send your written request by email or in writing. No oral mention.
I just have one request. The matter tomorrow. I mean, personal difficulties.
It's before this court.
Before this, 106. Only tomorrow, if you lordship will not.
Okay, we'll accommodate.
Much
you.
obliged.
No oral mentioning.
Very well.
Everybody who has any
We will circulate an email.
By email or by written letter. Giving the reason why you want, what's the urgency.
So should I also circulate an email? Much obliged.
Not required. Not required.
Not much obliged.
Lordship, at the bar, your Lordship. Generally, we are doing lot of time. We are not getting response, your Lordship. Can you take care of that?
We'll take that.
Please, Lordship.
Don't
Lordships, in item 18 today's list, Lordships. This is a matter where we've moved an application for withdrawal of the award amount. This is a 2003 award.
Just wait for something. Let it come.
Very well. That application may be listed, not the main matter.
We'll see.
My lord, it's education matter and party in person. It's 49 times it listed, but not taken up due to some reason. And
Just wait.
Before I met earlier the court number 1, and now the chief has retired. So I'll request you because
please send your email. Please send your email.
I sent sir more than 7 times, and it is tentative date is listed for tomorrow, but it is again deleted.
Okay,
it is again
just give your details.
Yeah, I sent on the mail today. Morning also I sent. Day before yesterday.
Item 1 will go before Justice Oak's bench. Probably it's been wrongly marked. I made a mistake because my brother cannot hear this matter, so it will go before Justice Oak's bench.
Would my lord
Because there are
indicate?
two benches which are hearing the senior bench.
Please, my lord
We
indicate.
listed before the bench, headed by Justice Oak in the week commencing. Is there any urgency?
My lord, that trial is not going on for last 10 years.
It's a transfer petition, my lord, and the High Court is monitoring. Yes.
Yeah, my lord, otherwise also I was to seek some time in view of change in the circumstances. My lord. He is not a chief minister, but if your lordships are not taking up, my lord,
No, we will not. Week commencing 2nd of December 2024.
please, my lord.
Not please.
Wait, please, my lord.
Lord, this is for the grant of bail by order dated 6th August 2024.
That's one thing.
Yes, my lord.
Now the allegation against you is that you had given a letter also.
Yes,
My lord.
lordship.
The allegation as contained in the complaint.
And number 2, there's a written or WhatsApp text which they have also circulated.
Lords, if that was the case, that ought to have been the first thing mentioned in the complaint. Payment is coming from 2000.
not payment.
The alleged letter that the report also mentions the learned complainant is also relying upon is of 2021. The payment has come from 2018 onwards, my lord. 2018 staggered cash payment. It has been happening. I have
When
taken
was the last payment made?
2023. Sorry.
2023, Your Lordship.
How can it be?
I'm appearing on behalf
1
of
minute,
the
please.
state, Your Lordship.
Just 1 minute, please. That's one thing which I noticed. Come to page number. You have said that the payments were received between 2018 to 2023.
Defector complainant.
Now, in case the letter which was given in 2021 was found to be false and fabricated,
Yes.
then where's the question of payment in 2023? Because that letter of appointment, come to the letter of appointment. Come to the letter of appointment. Page number,
12 of their IA, my lord. Connection A1 in their IA.
this letter is dated 14/5/2021.
Yes, Lordship.
Now,
20,
1 minute, please listen.
Lordship.
Don't answer without. This is a letter of 2021. Now come to page number 16 of the letter. The government directs the following revenue to fund officer, so and so, who had completed 1 year of service with reference to the year of allotment appointment, so and so, in grade number so and so. This is factually incorrect. Number 2, it also says are eligible for draw areas so and so, so and so. No representation will be so and so. He is directed to report to duty before the revenue officer within 10 days from the date of receipt of this communication, failing which this order will be liable for cancellation without any further reference. So if this is 2021 letter, why will you make payment in 2023?
Lordship, thereafter he promised that he will he promised a land or a petrol pump, that he is influential, he can make anything.
Please, now you're changing your stand.
Lordship, I'm appealing
Basically, a
on the
recovery
state-
proceeding instead of a money lender is trying to extract money.
File the state government, why you were wanting to withdraw your report?
Lordship, I filed a subsequent report, Your Lordship. There was some mistake in that first report where he has addressed me in that two address, Your Lordship.
Okay, this
Your
is the
Lordship,
subsequent, now the report which you have recorded is the subsequent report.
No, this is the report which was filed before the High Court as per the last order. But in the two address, there was some mistakes. Therefore, I withdraw that. I filed a fresh one, Your Lordship.
He has not referred to cell phone audio conversation.
No, Lordship, I spoke to the IO, Lordship. There are cell phone conversations and WhatsApp messages as well
But
between.
the WhatsApp messages which he has relied upon, just look at that message.
It's 2021, Your Lordship.
Just come to the message which he has relied upon. Page number 20. This is the only message he's relied
And
upon.
also there are the conversation between the complainant and the accused, Your
But
Lordship.
he has not mentioned about anything like that.
But it is there in our investigation. I can file a status.
So why should we keep on adjourning the matter? Look, Prime Minister,
Yes, sir.
it appears to be very odd that a person who has given the letter of appointment in 2021, which is found to be fake, will continue to make payments even in 2023. And from 2018 till payments have been made till 2023.
Otherwise, our investigation reveals that.
Look, 26 lakhs is a huge amount, but
Yes, sir.
it's possible you may have given it, the person may give it to secure employment. But one thing is very clear, that they would not have, and what's the date of this SMS?
This is
At page 20?
2021, Your Lordship.
What date?
10/7/2021, Your Lordship.
10?
10/7/2021.
And what's the date of the letter?
May 21.
So why will he write that letter?
Lordship, I don't, that is the.
Why will he send the SMS?
To answer that whether why he has made the payment after that alleged the appointment letter, Lordship. But
When
our
a
investigation
person is
will-
given a fake appointment letter,
Yes.
or a letter which says, you are appointed, will a person keep on making payment?
That the defective complaint has to complain, but our investigation reveals that he has produced the.
Any
Yes,
other
given
case
the-
against him?
No, my lord.
No antecedents.
No, my lord. No other case of similar nature.
Yes, very
A1's bail also rejected by the High Court, Your Lordship.
4 years here, but the fact of the matter is, this letter, obviously, anybody will be, if he used to take appointment within 10 days, he would have jumped at it.
I quite see there are transactions after 2021, but apparently, Your Lordship, it's a forged appointment letter, Your Lordship.
1 minute, please. The question is whether he forged it or somebody else has forged it.
He forged the letter. There are audio
That's an allegation.
There are
But
conversations
then
between.
the question cannot be, you say that he forged the letter, that question can be only answered by referring to the antecedent circumstances. Now, if he says I've not forged it, he says he has forged it, so we'll have to decipher based upon certain circumstances.
Yes, sir.
A letter which is forged and fake, nobody will keep on making payments even after the letter is given. How much payment was made after May 2021?
Lordship, post 2021, we had not made any payments. All the payments are before.
1 minute, please. Come to your complaint. Come to your complaint.
Lordship.
What you are saying is wrong. In your complaint, you have mentioned that you have made payment post 2021. Come to your complaint.
Lordship, the FIR.
Yes, it's mentioned. Come to page 26 of the main paper book.
Lordship.
Paragraph
Lordship.
number, second paragraph on that page.
Lordship, but no payment has been made in 2023, Lordship.
1 minute, please. Come to your complaint.
Lordship,
Lordship,
it is mentioned that till 2023, Lordship. It is mentioned 2023.
And how do we know this? Obviously, you would have verified when you filed the complaint.
Lordship, yes, but Lordship, but that was in anticipation that he would be giving us a property and the petrol
1
pump.
minute, please. That's not the allegation made here. Then it's altogether anticipation and giving up a property. That means therefore you're then aware that he's not going to get you a job. This appears to be a money lending transaction which has been now given.
It was a loan taken. I had given checks. He has filed those checks. Checks bounced. Thereafter, this complaint has been filed.
That's correct.
But may I make a humble submission, my lord? Last payment is made on January 2020. That is the last payment according to.
Yes, Lordship. This is the.
Please, why did you mention in the complaint till April 2023?
You mentioned a date also, 12/4/2023.
Before the complaint, my lord.
But please, that's in your written complaint.
Till that period, we have paid this much. Is that mentioned?
1 minute, please. That's not how we read it. We also can understand what you have written. Read that sentence. Read that sentence.
If I come to complaint, totally paid so amount in 8 installments from the period February.
Mentioning the number of installments also.
8 installments.
You have mentioned number of installments and then you say from this date till 12/4/2023.
Even otherwise, whether that appointment letter is forged or not, the investigation has to be conducted.
On exercise, it's unbelievable that he could have forged it. Exercise so. Because if the appointment letter was fake and he was to take employment.
There was a telephonic conversation between the accused and the complainant, Your Lordship. Not only that forged appointment.
You have not filed the transcript of that conversation.
We'll file it.
He has, in the complaint, he does not mention about it. He also only mentions about WhatsApp messages. He has not mentioned about any telephone conversation. He's not mentioned at all about
We'll produce all the documents, Your Lordship. We'll file the transcripts of the conversation, Lord. Grant us 1 week time, Your Lordship.
Leave it
File
now,
that, Your Lordship.
we have granted you time on the last, that's over.
Lordship directed us to file the report. No, Lordship directed us to file the report which was filed before the Honorable
I'm sorry, you should have gone through these documents we have gone through the documents within 5 minutes.
Yes, Lordship, it's all Tamil, Lordship. It has to be translated, Lordship.
I'm sorry,
1
please.
week time will file.
No, please, leave it now. Leave granted. We have heard. There are two contradictory versions emerging. Full stop. In the complaint filed by Kumati and Suraj. No, sorry. What's the name of the complainant?
Sudarshan, my lord.
Sudarshan.
Yes, my lord.
He is alleged that he made payment of rupees 26,89,500 in 8 installments from February 2018 to 12th April 2023. But the appellant, Suraj, did not act, did not act as per the promise, that is, secure a government job for the complainant. Full stop. Our reliance in this regard is placed upon, and reliance and support is taken from letter dated 21, 14/5/2021, which is an appointment letter in favor of the complainant Sudarshan and requires him to report for duty before a revenue officer within 10 days. Full stop. This, full stop. In case of, it is obvious that the complainant would not have been appointed on the basis of the said fake appointment letter. Next page. Reliance by the complainant is also placed upon SMS, which gives the details of the complainant who is to appear in the examination, which was to be held in 2021. Full stop. Next page. It is also alleged in the complaint that subsequently the payment was to be treated as equitable mortgage for an ancestral property which was to be sold after valuation, which was for which was to be evaluated. Next page. The stand and stance of the appellant Suraj is that rupees 26 lakhs 89,500
500.
was given as loan on different dates between 2018 to 2023. To stop. It is submitted that these dates reflect the payment over a period of time reflects and supports the case of the appellant Suraj. Full stop. It is submitted that payment in 2018 could not have been made for appointments sometimes in 2021 or for appearing in exam in 2021. Next page.
Actually, they may be directed to join the investigation, Lordship, as and when.
I've already joined.
Right. In view of the facts of the present case, we feel that the appellant has made out a case for grant of anticipatory bail, and therefore, in the event of being arrested in FIR number 231 of 2023, registered at police station so and so under section so and so, he shall be released on bail by the arresting stroke investigating officer stroke trial court on terms and conditions to be fixed by the trial court. Stop. The petitioner will join investigation and will also comply with the conditions mentioned in section 438 of the Code of Procedure 1972. appeal is allowed and the interim judgment said and the appeal is allowed and disposed of in the above terms. We clarify that the observations made in this order and grant of anticipatory bail will not be treated as expression of opinion on the merits of the case.
Lordship, may I mention one thing only before the court, Lordship? Lordship, may I mention only one thing for the factual correction of the order, Lordship?
Yes, please.
Lordship, the FIR does not say that I had paid till 2023. Page 26 is the averment of the public prosecutor in that order. That is a typographical error, Lordship. Lordship, if my seat mentioned page 26, Lordship, page 26 only for a moment, Lordship. The page 26 is the averment of the public prosecutor. However, my FIR does not speak the same words. My FIR speaks that after my...
Please, but, okay, say the public prosecutor.
Yes, Lordship.
I'll mention public. That must have been
But
made
my
up.
FIR does not speak so, Lordship.
Must have been public prosecutor submitted de facto complainant searching so and so, accused of
Lordship.
so and so, and believing the words, the complainant totally paid between, okay.
This is not my complaint, Lordship. My FIR is my complaint, Lordship. It does not speak so.
It is accepted by the state that there is no other case against the appellant. There is no other criminal case pending against the appellant.
Published. Grateful, madam. Obligement.
Item 3, Lordship, the service.
Lordship, item 3, we appeared in compliance of your Lordship's order, my lords, before the investigating officer on the 4th of October, along with my father, and we are appearing as and when we are being.
The service is not effected on 4 and 5.
4 and 5 service is not complete. I am appearing on behalf of the state. I'm seeking 2
What
weeks.
is the evidence against her otherwise?
Only
She's certainly the wife. There is no
Yes.
doubt about it. She's certainly the wife. But is she a Pradhanashin lady?
she is a Pardhanashin lady. Lord.
Then how will the accused ever, how will the complainant would have ever met her?
But there is a direct transfer from her account to the other person's account, it appears. Although on 4th, she has appeared with the in front of the investigator.
Only 30,000 rupees was transferred to her account.
Yes, Your Lordship.
And that she's ready to pay back.
Yes, Your Lordship. That is correct. She's
Is there any other amount transferred by her account?
not.
And if she is a Pradhanashin lady, we don't even know whether the husband was using that account.
Lordship.
Because she wouldn't have given a photograph, or even if she has given the photograph, she would have paid only once or twice.
That's correct, Your Lordship. She's appeared on 4th. She submitted the copy of the passbook and the phone numbers. However, the husband is absconding. We requested her to furnish us with his whereabouts.
The husband is absconding.
Yes, Your Lordship. He's absconding. So that is the difficulty we are facing. Otherwise, in compliance of Your Lordship's order, she did appear
Not
on.
give you details about her husband's whereabouts.
Nothing, Lordship. She's not cooperating with respect to
Lord,
his
I-
whereabouts.
Still in your account.
Money is still in the account, my lords, and what
Pay back the money.
we'll pay back the money, my lords.
And is there any other transaction in your name?
Apologies, my lords.
Is there any other transaction in your name?
My lords, there is a separate account which she has opened for her sewing work, etc. This bank account she is not touched at all.
No. Doing work, etc., is something which everybody does.
Yes, my lords. So she has
States that-
3 minor children, my lords. So
That's fine. That's something separate.
yes.
Is there any other bank account where there are transactions relating to money, monetary transactions?
My lords, I have a separate bank account where the sewing transactions, etc. are happening. If your lordships wants a
That will
detail.
be hardly about 1,000, 2,000 rupees
Yes,
a
my
day.
lords. Those are the only 2 accounts, the one in question and the second one which she
That
maintains.
will not have transaction going into lakhs of
No, my lords. No, my lords.
or even 1,000 rupees a day.
No, my lords. Nothing like that. Very menial amounts, my lords.
Why is respondent number 4 and 5 not served? You could have served them. They're the complainants.
They are the complainants, Lordship.
My lords,
Service
4 is the
not complete.
complainant, 5 is my father-in-law. And they say that no person of that name is present over there, even though he filed the application before the High Court.
Avoid.
4 may be permitted to appear, Lordship. They may serve 4.
Right. Respondents number 4 and 5 remain unserved. Steps will be taken for service will be taken within 7 days. 7 days. Notice will be given thusly. Notice will be also served to the SHO of the police station concerned. The petitioner will furnish details of petitioner and her father will give mobile telephone number, the mobile telephone instruments to the police to enable them to, as it is stated, that what's his name, the accused, primary accused?
Faruqi.
As it is stated, that Faruqi, Furqan Ali Nazmi,
Furqan Ali.
Furqan Ali Nazmi, father of the petitioner, the husband of the petitioner is absconding, and his whereabouts remain unknown. The instruments will be given within a period of 3 working days and will be retained by the police for a period of 7 days unless, and thereupon returned, unless there is some evidence or material to show, unless they contain evidence and material which may be relevant for the investigation.
But the state may be permitted to file its counter affidavit. We may be permitted to file a counter affidavit.
Respondent state of UP is also permitted to file their replies to a counter affidavit within 20 days.
Most
Or
of
make it 3 weeks. Rejoinder, if any, within 2 weeks after service of the counter affidavit. Interim audit continues.
Great. Most obliged.
May please, Your Lordship.
Week commencing 3rd week of January.
May please, Your Lordship. My Lords, I'll deal directly with the 3 questions. I was going through my facts, but Your Lordships put 3 questions to me the other day. Let me cut to the chase, my Lords, and come down to what exactly the issue is. Question number 1, that 9,040 shares, whether the transfer to me was valid or not. Question number 2, whether the decision for the rights issue was validly taken or not. My Lords, leaving everything else out, the whole issue arises, as I pointed out. If Your Lordship would like, I'll just recap it for 2 seconds and no more, 2 minutes and no more. My Lords, there was this company. The Auroras had the company. The Auroras company was brought up in sale under Section 29 of the Securitization Act, and that was purchased. When purchasing it, certain shares were bought by the appellants, who were 4. There were 5 totally who had formed a company, 4 of them. And certain shares were bought by the respondent, who was the 5th person of the group. Which now, at that time, in 1990, as the evidence would show, Auroras took consideration and said they would transfer their shares to me. There was a clause, an article, which clearly said it should only go to existing members. At that time, none of us were existing members. Auroras were existing members and their own people who were there. Now, their preemptive rights, therefore, is not amongst any of the 5 of us. The preemptive rights would have been amongst the then existing persons. So that is not the quarrel today. We purchased the Aurora's 9,040 shares, but it was not registered. The transfer was not registered. Therefore, at the close of the last session, my Lords, Your Lordships had put the question to me, if it was not registered, how did you become the owner of those shares? To which I was pleading, based on Howrah trading, etc., the equitable interest in the shares. Your Lordships then said, but then the shares, on the date when you came out with the transfer of the shares, and they've directed you have a meeting and transfer the shares, on that date, since the NCLT said have a fresh meeting and approve the transfer, on the date of that fresh meeting, now the Auroras have sold, then it should have gone equally to the others. How could there be, then the existing members had an equal right to purchase those shares, because the Auroras will deem to be still members of the company. And if they are still members of the company, then the preemptive right would be to all the members. They cannot give it to somebody else. My answer to that is twofold, my Lords. Your Lordships will see the direction of NCLT, because while my Lord has seen various findings, Your Lordships haven't seen the actual directions of NCLT. The NCLT directions at page 446 are very clear. Now, let's to summarize what the NCLT had said. They said that two things. They said the appointment of directors from our group was not proper and said that appointment was without notice, ergo bad. Because of that, the consequential orders came to be passed. Therefore, your sale, which took place then, to be approved, has to be approved thereafter by the directors, number one. Rights issue, they have upheld. But please see the directions, paragraph 146, and I feel those directions are perfectly correct, which is why we did not appeal it. Number one, the original board of directors comprising P2, P3, R2 and R20 is restored, i.e. the new directors appointed are not there. So it should be taken that they are not directors of the company. The respondent company in the first meeting of its members, this is important, shall take a fresh decision of appointing R3, R6, R8 as directors. That is an EGM. So obviously it can be done in an EGM. EGM was convened and they were voted in. To which your lordships will ask the question.
Who voted in?
Exactly. Your lordships, these are the facts I have now got clearly clarified because I'm ready for my lord's questions. The EGM was held on 6th January.
We need not go into that question, but the fact.
Auroras attended the EGM themselves and voted for the new directors. The Auroras themselves, your lordship's question would have been who voted those Aurora shares? No, Auroras attended the EGM. I have the minutes. I'll be showing your lordships the documents. It's all part of the record.
That subject matter of the subsequent, there is a subsequent also a petition or operation mismanagement petition which is pending. There's a subsequent petition also.
Yes.
That's a subject matter of the subsequent.
That's in 2020, not the matter before your lordships.
So, okay. So therefore,
neither of the matter before your lordship.
Therefore, the issue of registration of 9,040 shares is struck down.
I'm coming to that, Madam. Please, I'm answering the question to your lordships one by one. The first direction was take a fresh decision of appointing R3, R6 to R8 as directors. Now, R3, whether it is struck down, legal effect of it, whatever, I will address separately. But I just want to show even the order as it stands, there is really no problem. Because after this, there was an EGM held on 6th January 2018. That's not subject matter of the other matter before your lordships. And that EGM, my lords, they first challenge the EGM, then there's a consent order where they consent on 13th December 2017 to the EGM being held. There's an order which is at page 187, I'll be showing my lords, where we moved saying they're trying to obstruct the EGM which we are convening. They came for the hearing and consented to the EGM. So the EGM is held on 6th January 18. In that EGM, the directors are appointed. And in that EGM, so that probably envisaging problems which could arise, the Auroras themselves came and voted their shares. So let's take it at the worst. The shares remain with Aurora. If that transfer was bad, the shares remain with Aurora. So yes. Aurora votes. And my lords, the new directors come in.
Yes.
And all other independent shareholders vote and by majority. These are the new directors. Now the board, there can be no question of, as of that date, that these people are there. Now the new board meets and on 24, 2019.
One moment, please. Subject matter.
Lords, put aside the rights issue. Assume there's no rights issue. With the Auroras and our shareholding, there's 53%. Aurora's objection was, how did you go on the Aurora shares? I just, 2 more minutes, my lords. I think I'll be able to answer all my lords' questions together. What is important is, thereafter, what is important is, those articles which are referred to, which gave a preemptive right, those articles were removed in 2016. And it is on record that notices of the meeting for amendment of articles was given and received by them, because they themselves in their petition admit it. I'll show your lordships. They did not attend. And
Was it one of the resolutions mentioned, proposed resolution, or which was taken up as a
no,
the last item?
Show me the meeting. I appreciate that.
Continue further. Continue.
I'll just
see the directions.
I'll just continue my facts. In 2016, those articles were removed. Now, the new board, here again, my lords, the new board on which again they have notice, the new board meets on 24/2019 and approves the transfer being registered on 24/2019. It approves the transfer being registered. Aurora has no quarrel. They've received their money and gone. As between us, there were clear case of equities. I don't need to argue that part, my lords are well aware of the law on that. So it is duly registered, and we are talking about the year 2019. So therefore, my lords, those Aurora shares, I also would like to address my lords on my legal rights, even assuming it was not registered. But factually, pursuant to this order, and this is part 2, and now can I read the rest of the order, my lords?
Yes.
The order at paragraph 146. Respondent company, first meeting of its members shall take a fresh decision. That decision is taken and cannot be questioned at this juncture before my lords. 3, the meetings of the board of directors and the shareholders meeting be henceforth conveyed by that there is no problem on. 4, respondents to hand over statutory records. 5, newly constituted board shall be competent to take necessary decisions as may be required in view of the observations. 6, the decision dated 14/8/2010 in transferring 9,040 shares of erstwhile promoters is set aside, and R1 company shall take fresh decision on the transfer of these shares, keeping in view the observations. So, my lords, this order, it was read to my lords as though it ended with setting aside. That was not the judgment. Judgment said, since on that date, we have held that that transfer could not have been done, you have paid the consideration, you have received it. The directors of the board, after you have convened the EGM and you have what the directors are, will take a decision. Directors take a decision.
That's subject matter of the new petition.
That's not here, but I'm trying.
Now, the only
I'm
issue
saying, my
before
lord, there's
us-
nothing wrong with this order. The
No.
point I'm saying is,
No, he's not agreed by these directions.
then there's
What
nothing
he's
in the
agreed
case.
by is the non-grant of further relief, because last part also says, come to the last part. The petition to claim rest of the reliefs is dismissed.
Yes.
So what he has argued is, my claim with regard to the issue of the rights share.
I know, no, we'll
One
come. Right share, my lords, on merits that I'm arguing separately.
that's
Please
the
allow
whole
me to
issue.
argue that separately. I'm only on this transfer thing, the first part.
The point is this, he's not even worded on that score. What he's saying is, the appellate tribunal rewrote the order on
No,
first.
that
fight.
also I'll show my lord is not correct. I'll show my lord that. That also I will show your lordships is not.
Where you are not in appeal.
My lords has not heard me on that. Your lordships will hear me on that. No, can I just take 2 more minutes? So let us take this judgment. What can he be aggrieved about in this judgment? He said 9,040 shares transferred in 14/8/2010 is bad. Judgment upholds that. The judgment is dealing with a case under 241, 242. You have to give full and complete relief as far as possible for the welfare. So to give direction saying, have a fresh meeting, decide that in a fresh meeting, nobody can find fault with that. So his first relief on 9,040. The second part he is aggrieved by is the rights issue. My claim to set aside the rights issue has been wrongly rejected. I'll show your lordship the reasoning for that rejection, but I'll deal with that separately. I don't want to combine the two arguments. So far as the transfer of the 9,000 shares is concerned, my lord, no fault can be found with that 9,040 shares. No fault can be found in the order. My lords are sitting in appeal over this order. I've told your lordships what has happened subsequent to that order. But this order cannot be faulted for saying, have an EGM. Since I'm saying your directors were not correctly appointed, have an EGM and vote directors. Nothing wrong in that. So far as 9,040 shares is concerned, I'm setting aside what happened in 2010. And if you want to transfer it, whatever, let the new board decide. Nothing wrong in that. So that part of the order he cannot be aggrieved with. He's on appeal against this order. What has happened? I'm just pointing out to my lords that subsequent to the order, what all has happened. To show your lordship that the 241, 242, does my lords consider the holistic approach and saying these are the major people. He's the patent holder. I'm the patent holder of all these patents. He is a minor shareholder from the beginning. Aurora's also sold out to me. Aurora's also said. Therefore, looking at it from 241, 242, an equitable jurisdiction, can it even be said equities are against him? All right, legally, certain errors may have been made. And on a lighter vein, I reread the judgment, my lords, in Needle Industries. My lord is right. My lord, the Chief Justice is right. While the negative was emphasized, the positive has not been specifically stated. I reread it and I realized that. I'll come to that, man. So, my lords, there is nothing wrong with this judgment as it stands, except I'll come to rights separately. Now, my lords, let us see how this was dealt with by NCLAT, and I'm going to show your lordship it's a totally spacious argument taken that the NCLAT decided anything else. The NCLAT did not modify the judgment because, my lord, there I'm buttressed by about 3 judgments of your lordships where I can, in defending an order, defending a judgment, I can raise issues raised and even decided against me by the lower side without having to file cross objections. I'll show my lord that.
That's correct, but limited. Look,
NCLAT did.
Just one. That's correct, but limited only to the effect that the final relief cannot.
It's the same. It was not modified.
But here, there's a difference between decision or the findings recorded on issues and the final relief. Where final relief is granted, you cannot challenge the grant of final relief.
Absolutely. And my lords,
or if you are going to...
What your lordships did not notice when it was being argued by my learned friends is that there was no change in the final relief. That's what was not pointed out.
The 4 grounds on which relief was granted to them, the appellate tribunal held should not have been granted.
No. Sorry, my lord. Sorry. Not at all. I'm going to take my law through that. And if at the end of it your lordships feel so, then I have nothing to argue. I'm showing your lordships it is not so.
Come to the rights issue part.
My lord, can I just deal with the rights issue separately in a second? Okay. But this, I first have to, I'll explain to your lordships why. Let me take the rights issue at its worst. At its worst, you set aside the rights issue. What happens? I'm going to show my lords it would not be set aside, but I'd be asked to regurge the amount taken. There are various reliefs, but that's a different matter. Even if that rights issue is not there and the rest of it is there, I hold a clear majority in the company with the 9,040.
So agree to setting aside of the rights issue?
No,
they'll go home. The dispute continues.
No, that I'll show your lordship. If your lordship feels at the end of it the rights issue is bad, your lordships will hold it.
Look, the fact of the matter is, today the rights issue may be at the time when it was.
I just want to know I can proceed from the transfer.
Yes,
I just want to know this, from the transfer aspect.
We are on the rights issue. The issue is when the board of directors itself is not validly constituted. Can they direct issue of rights issue? That's a simple issue.
That I can answer, my lord. That on law I'll answer, my lord. There's no problem. On that I will be able to answer, my lord. But I wanted to first finish this 9,040 shares
Please do.
because this is of some importance to
Look,
me.
there's two ways to deal with it.
Now, my lords,
Just one second. We set aside the rights issue, but ultimately it will not make any difference because in the subsequent EGM, the appointment of directors has taken place. Two, the subsequent directors have also accepted the issue of 9,040 shares to new shareholders. Three, the rights issue today, after you get majority, when the shares are transferred in your favor, the rights issue becomes a secondary issue. But what you're forgetting also at the same time is he's challenged the second EGM. He's challenged in a separate new.
my lords, I'll deal with that because there I have a clear case to answer. I have an easy case to answer. He has received notices. He has all that I will answer there. That's not before my lords.
That will only show legality, but we need not go into that.
Even on
we need not go into that.
Need not, because what your lordships are saying is this order of NCLT. Let's start with that first proposition. Can this order of NCLT be faulted qua the directors and qua the transfer of shares? I submit this order is perfectly valid on those 2 points, which is why I did not challenge this order. Because I said, all right, if you say the directors were wrongly appointed, I'll call an EGM. I'll have directors appointed. If you say the 9,040 shares, the new board will have to decide, fine, I'll have the new board decide it and let it be decided. But what your lordship is judging today is the correctness of this order, not subsequent, whether they've challenged another your lordship is seeing the correctness.
You're right on that.
So this order is correct.
Shows.
I'm now coming to rights. But before that, this order is correct so far as directors are concerned. This order is correct so far as the 9,040 shares are concerned. Well, before leaving that issue of 9,040 shares, I need to tell my lords one more thing, which is of great importance. Because if my lords are going to decide on that, it has a big bearing because of various reasons. It is my case that once it is held that the transfer took place. My lords, on this point, I believe I'll succeed in the 9,040, sustaining the order regarding this. But even otherwise, I want to take it differently, that even in the 9,040 shares, so far as those were concerned, the transfer which took place in the year 1990. And I'm sorry, 1998. That is the date it took place, Auroras, etc. The evidence as between the competent parties, the relevant parties to the transaction, the Auroras and myself both accept it. That consideration passed, transfer was completed. Fact, transfer was completed in 1998 inter partes. Fact, it was not registered on the register of members till 2010. Ergo, third, legal fact, it is not binding on the company. Company is not bound. Company recognizes the fact that he might be a statutory trustee or whatever. But for the company, if you want to requisition a meeting, if you want to get dividends, whatever you want to do, the company looks only at him. Point here is, as between the shareholders, it is not binding on the company. It is binding on Aurora. It is binding on me. So far as the other shareholders are concerned, so far as that transaction is concerned, if that transaction, the article said to the existing shareholders, none of us were existing. Aurora sold it to whomsoever they wanted. It was Auroras were free to sell it to me. Aurora sold it to me. Property in the goods passed to me. So far as the company is concerned, it is not registered. The company recognizes only Aurora, does not recognize me. But between me and Aurora, we can't have a dispute. As between the other shareholders and me, there cannot be a dispute with regard to these shares because they are not saying that there was no transfer in 1998, this was the intention, etc. They are saying.
They are disputing that. They are
No,
disputing.
I'm sorry, my lord. Please see, the whole case, Auroras themselves come forward. Auroras themselves say it. Your lordships will see the entire order. There is nothing to show that such a transaction did not take place between me and the Auroras in 1998. I'm saying so without reading your lordships the entire order, but your lordships will not find one whisper that such a transaction did not take place. Ipsi dixit, anything can be said, but your lordships will not find one whisper of it. Now, here are other shareholders who, if the transaction did take place in 1998, had no right even under the preemptive clause because they were not shareholders also in 1998. For the shares to be offered to them, they were not shareholders. We were all newcomers. So the preemptive clause did not apply to them. It did not apply to me. It did not apply to any of us. Now, in 1998, if that had taken place inter partes, the other shareholders were part of this whole scheme of taking over this company and shares being allotted to each one. They, the my lords, cannot at a later juncture say, excuse me, it's not registered. Since it's not registered, I today do not recognize that you're owner of the shares. So what becomes important is for your lordships to decide inter se parties, not inter se company. When did the transfer take place in the property? When did the right, title, and interest in the property pass? Inter se parties, shares are movable property. Shares are freely transferable as movable property. Movable property transfers upon delivery and consideration. Aurora say property passed. I say property passed. Other shareholders have nothing to say about it. The whole case is in 2010, when these shares were registered, A, the board was not rightly constituted. B, if the date of transfer was 2010, on that date of transfer, I had a preemptive right. So the whole case is the transfer takes place because the transfer took place in 98. The preemptive right to be exercised was the day of entering into the contract. My lords, how is a preemptive right? I say I'm transferring my shares to Mr. X. Does anybody want to exercise a preemptive right? If they don't exercise it and I transfer it to X, X gets title whether or not it's come into the members. And none of the other members who did not exercise that right can turn around and say, no, it cannot be entered in the register of members. So therefore, my lords, as far as they are concerned, their only ground is the transfer took place in 2010. In 2010, the board was wrongly constituted. All right. What was wrongly constituted? The board, therefore, you could not register the transfer. But the transfer had nothing to do with the company. The transfer had to do with the two parties 12 years earlier. The ministerial act of registering the transfer had to be done by the board. Board is not a correctly constituted board, ergo it's bad. But they take it one step further. Their argument is transfer takes place only in 2010. If it takes place only in 2010, then they say they have a preemptive right. Now, A, as a matter of fact,
Need not go dwell much into it on this aspect because the fact of the matter is we are not required here to determine the intrinsic rights between Auroras and any other person. The fact of the matter is that NCLT held that the transfer of shares as recorded in 2020 to modify or make a
2010,
2010, sorry, 2010 to modify and amend the register of shareholders is wrong.
I'm with my lord.
So
now I'm just going.
We need not argue on that.
No, I'm going just one step further. One step further.
The only issue is
My lord,
of
I
rights.
take it that the transfer did not take place. I'm
The
now taking
only
their best
question-
case.
Only question is of the rights issue.
No, I'm now going to their best case, just on this 9,040, and I'll cease with that. Their best case. The transfer does not take place when you and the Auroras decide. The transfer takes place only on the date that it is duly registered. And on the date it was duly registered, I was a shareholder. And how can shares be registered in violation of the preemptive?
This is a gray area. We don't
No,
want to.
I'm going one step. Even that I've answered, my lord, straight away. Because
Let me put it very clearly. Why I feel it's a gray area. Both of us were discussing that. Why it's a gray area. Normally, you're right. Registration does not result in transfer. It's a ministerial act. But where the preemptive right is there, there is a preemptive right, and the law says that only registered shareholders will be treated as shareholders. The situation may be not be as you're saying.
my lord, I go with this.
May not, but we need not go into that question for the simple reason that the transfer by 2010 in the board of director meeting of 2010 has been set aside.
And now, my lords, to answer my lord the Chief Justice there, I have a point. I have an excellent point on this I want to place, because it's the same question my Lord Justice Rajay Kumar put to me the other day. I have the answer to it and I would want to say it. Let us take the date of transfer as the relevant date. My lord, I take it. And the preemptive right has to be exercised on the date of the registration of the transfer. In that case, the transfer has been set aside in 2010. The date of transfer is 2018 or 19. Then that's the relevant date. On that date, there was no preemptive right. The articles had been amended. You can't have 3 dates. You can have 2 dates. Date when the interstate transfer took place, or the date when the transfer was approved by the board. One of 2 dates. You can't have a third date.
You had fresh share transfer forms in 2010 and again in 2010.
I don't know, my lord. That is not a subject matter, but
earlier you had said that in 2010 you had.
My lords, the board decides, because it can only be 2 things.
As a matter of fact,
As a matter of fact, I'll check that up. I'll check that up for my lord. I don't want to give an answer without being sure of the. But I'm putting it this way. The board is seized with a request to transfer. I'm going on their best argument and what fell from my lord the Chief Justice as the gray area. The board is seized with a request to transfer. On the date the board is seized with that request, they look at the articles. And if they find it's against the preemptive right in the articles, they refuse the transfer. So there are 2 possible dates. One date of the actual transfer, Howrah trading, etc. 2, the date the board is seized with the decision to register the transfer. There can't be a third date. Because if your lordship goes on the relevance of the date of the transfer deed, then please go on the relevance of the date when the transfer deeds were handed over, blank transfer deeds. Please go on the date when the consideration was exchanged. We can't have 3 different situations. Either it's one or the other. If it is one, that is the date when inter partes, that sale took over, transfer deeds handed over, etc., etc., matter ends. If your lordship say no, because of this preemptive, it could be a gray area. It has to be the date the board is seized with the question to be decided. Then please go on that date. On that date, there's no preemptive clause. So either way, where's the findings on rights issue?
question is this. The rights issue would have been also given to the 9,040 shares. And that means the new shareholders
And I would have had the right to the rights issue.
may have
So-
got the right,
No,
but it would have been registered in the name of Auroras.
We'll come to the rights, Malad. Separately, I'm now dealing with the rights. I want to come straight to the rights. I just wanted to complete my submissions on this other side, on the 9,040, because that is, my lords, it's really a very vital part of this whole case. Because, my lords, it's a very difficult case where four of us are together, one person there, and all these problems are being created on what happened then. So I want to show, my lord, also we must remember that it's an equity jurisdiction. Nothing wrong has been done. Here are four of us. And for us, and the Auroras want to give everything. What is the oppressive behavior shown? That's the first question. How have they been oppressed? That is the first question. Yes, legality, board not correct, this, that, the other. That's a different matter. But please look at it from this oppressive angle. And I'm not asking for something which is unreasonable, unfair, unjust. And my lords, kindly see, next we come to this rights issue. Let me deal with this straight away. My lords, I have a convenience compilation which is only documents on record, nothing else. Just to refer to that, my lords. My lords, kindly first see page 142. They are all parties to these decisions. I'm showing you minutes of the board to which they have been 142.
Yes.
It was nothing new. Please see, my lords, I'm just giving the history of this rights issue, then your lordships will see it. My lords, kindly see various things are referred to, and on issue of rights issue, where is that? The exact part I marked it at 148. Starts at 147, item 9. Your lordship will see replay is needed to carry out sum of 2 crores approximately is needed to carry out updation, major repairs, modernization. Boiler replacement will cost 1 crore. Expenditure on modernization has been discussed with the lessee. Modernization existing will be done by the company as per the mutual understanding, etc. Just to show, my lord, that these amounts were required and discussed on that date. Subsequent to this, there was another board meeting which your lordships will find at page 114. 114. And my lords, I will show your lordships from their petition. They received notice of this meeting. Your lordship will see at page. Yes. And where is the rights issue? Where is the rights issue? Yes, 126. Item 33. My lords, I'll also be showing your lordship subsequently from their own petition. They've admitted receipt of these notices. The chairman informed the board that to meet the cost of replacement of boiler part as undertaken so-and-so, at the time of renewal or lease, it is required to raise own funds by issue of equity shares on rights basis to existing shareholders of the company. Therefore, after discussion, board has decided to raise the funds by way of a right issue of equity shares from existing shareholders. Following resolution is passed. This was, my lords, the origin of the rights issue. Now, your lordship will see this board meeting takes place and they receive notice on 8th August 2000. Please note these dates. 8th August 2012. Meeting takes place on 16th August 2012. This board meeting. Now, my lords, meeting is on 16th August 2012.
Under the law, how many days notice is required?
My lords, I think 7 days.
7 days.
Now, my lords, after the decision, at page 151,
if I'm not mistaken, the issue is decided against them or the relief is denied to them on the ground that in this case, the company had a practice of giving oral notice.
No, that's what I said. My lord has been shown that decision in parts. I'll now show whatever I'm saying, I'll back it with the decision on this aspect. My lords, let me explain. That was regarding the appointment of the board. That was my defense so far as the appointment of the board was concerned.
Not with regard to the.
Not with regard to all this. My lord, that was with regard to my appointment of the board, where I took the defense, that was the practice, and that was disagreed with and said, no, we do not agree with it. Maybe it was that.
Participated in the board of directors meeting on this
No,
16/8/2012.
My lord, they did not participate.
But then you
Yes,
suppose
yes.
to exclude the directors who had
My
participated.
lord, that's the second part of what I'm arguing. This rights issue, I'm answering, my lord, on two aspects. I have to give the factual foundation what happened and then the legal argument. The factual foundation, please note, these are important. Why? It was a decision taken. They were given full notice of it. They were asked to come. The meeting takes, they are aware. And I'll show you, lordship, they are aware because their own petition, which they file about 8 months later, refers to all this. Now, after the decision, a letter of offer, and there's no protest from them for any of this. There's no protest, not even one whisper of protest. I go on the basis, board badly appointed, etc. On that day, they hadn't protested to the board. Board was appointed in 2010. They don't protest about the board till 2013 when the other litigation, the other company, which is the other case, we have filed. 6 months after we filed that, or 3 months after we filed that, they filed this. When the board was appointed, XYZ, they never had an objection. On the contrary, they went with it. Now, please see, my lords, this rights issue, they don't object. They don't say, your board is not all right. Or we don't need a rights issue. They don't object to any of it. Not a whisper. My lords, all the arguments your lordships are hearing now was never raised in 2010, 2011, 2012, never raised. Now, at page 151, is the letter of offer pursuant to this, which admittedly they themselves say they received. And they do not object. I'm dealing with the second part. The second part is, could all this have been done with the board as it was? That's the second part, and I'm going to answer, my lord.
You're going to say that even if the board is irregularly suited, it will be valid, but that argument may falter in case the quorum is missing.
My lord is preempting me, my lord. You're preempting.
I know that. I know your argument.
I think your lordship
You can understand what you're laying foundation for that argument.
My lord, I didn't realize I'd become so predictable after all these years, my lord.
No, you didn't become predictable. You're doing what probably anybody will do. But we understand what you are coming to.
No, let me complete it then, my lord, in my way, my lord. I might slightly deviate from what's fallen from my lord. My lord, page 151. He gets this letter of offer on that date. And my lords, the date of receiving this letter of offer is 15/9/12. He is given the offer. He is given the date of the offer, everything. No protest. He accepts it. Admits receipt, as I'll show, my lord, from the pleadings. Please take it that all these are admitted, receipt. Then, my lords, on 5th October 2012, page 159, there's yet another notice of board meeting. Receipt admitted by him in his own petition. He files copies. In fact, not only admitted, he files copies as documents with his petition. Then, my lords, kindly see that this is the notice given on so-and-so date, agenda for the business to be discussed at the meeting, and it's on agenda, etc., etc. And, my lords, that meeting is held on 13th October, page 162. And pursuant to the response to the rights issue, the board then, at page 165, allots the shares. Again, he has received notice of the meeting. He has nothing to say about it. And this is done. Now, my lords, this board meeting, I showed your lordship from page 100 and 168 on, at 168, the form is also, Form 2 is uploaded. At page 168, the decision taken. And my lords, page 174, I'm sorry, 168, that form is uploaded, Form 2. Now, my lords, all this is completed by 13/10/2012, after full notice to him. We file a CP, of which he gets notice in the beginning of 2013 with regard to the other company, which your lordship will be hearing. We file it in October, but by the time he gets notice, that's a different issue. He files this CP in July 2013. For the first time, raises the objections your lordship sees, namely, board directors were wrongly appointed way back in 2009 and 10, that the decision to transfer shares.
His argument to that is very simple. There is no limitation period as far as that is concerned.
He's done it, but your lordship saying, sorry.
You missed that argument. He says we were going along smoothly. Whatever you took hold of one company, I took hold of one company. We're going around smoothly. When you file a petition saying I am responsible for indulging in operation of misconduct 1, I said I'll also then file it against you. You have taken me to court. I'll take you to court also.
My lord, I think your lordship has understood the other way around. Let me explain. The company he claims he is the person to run is not that other company which he says, I filed a company petition with regard to that. It's this company.
No, I'm sorry, I'm not making
I'm sorry, my lord. It's this company he says he was entitled to run.
There are two companies, no? One company which is purchased from the Auroras. The one is the parent company which was already in
sub-parent. There's an even...
Okay, sub-parent. Okay, sub-parent company. So what happened was, as far as the Aurora company is concerned, he was ousted. He's thrown out. As far as the sub-parent company is concerned, he said, I was in charge. I was enjoying the benefits, reaping the benefits. And therefore, when you hit him with regard to the sub-parent company by filing a petition...
I'm glad your lordships have put this question to me. His case is the exact opposite. Please, his case is... And I'll show your lordship his pleadings. His case is this company...
This is not my finding. This is his allegation.
Yes, and I have to rebut it, my lords. His case is this company was meant to come to him. And that parent company, he was not going to be in. But then he did some fiddle, and according to us, I use the word fiddle in that way, that he did something with the shares in that company, which is why we went by way of our petition. But his whole case has always been, this is my company, this one, not that. It's the exact opposite of what fell from my lord's mouth. My lord, so therefore, this is the factual scenario of the whole issue. Factual scenario. Now your lordship's questions to me. If that board was not properly constituted, those directors were subsequently held to be, it could not have been directors. What happens to this decision? How could this have been taken? Because the board was not properly constituted. I'll have two legal arguments for that to answer my lords. One, of course, I'll take my lords to immediately section 290 of the Companies Act. Because this kind of situation happens, my lord, 6 years after a company, the board is suddenly found to be illegally constituted. This is not the first time. It won't be the last time. By the time a matter is heard by the company law board in those days, the NCLT today, several years can go by, and it's held that the board was wrongly constituted. Now, what I'm going to say your lordships feel is, that's why we have section 290. If a person, because of the wrongful constitution, he has been prejudiced in a way that he could not do anything about it, then your lordship say we may consider it in one way. That's why I started with the factual scenario that he was not prejudiced by the rights issues not being offered to him. He was not prejudiced in full knowledge of it. He was not prejudiced in actual terms. But whether the decision is legally correct or not is the point in issue before my lord. I wanted to show my lord first that so far as the decision, its implementation, everything, he was a party offered the same shares. It wasn't that he was being ousted out. He was aware of the meetings. He was aware of the decisions. He was made the offer. He chose not to subscribe. And this is what happened. So factually, he can't claim. They created a situation behind my back, suddenly threw it at me. How do I know what the board said? Board decided X, Y. That cannot be his argument. And that becomes a very important argument in a 241, 242, as my lords know. But now let's see what section 290 says. And 290 is there with an avowed purpose. Acts, validity of acts of directors. Acts done by a person as a director shall be valid, notwithstanding that it may afterwards be discovered that his appointment was invalid by reason of any defect or disqualification or terminated by virtue of any provision contained in this act or in the articles, provided that nothing in this section shall be deemed to give validity to acts done by a director after his appointment has been shown to the company to have been invalid or have been terminated.
Was this section relied upon before the NCLT and NCLT to understand whether the proviso would be applicable or the main provision?
My lords, on the contrary, my lords, on the contrary,
Was this, no, first
no.
argument.
Answer first question, answer no. Why? Because the NCLT agreed with us that he was complicit in all these decisions and therefore cannot object. Agreed with us on that.
That's something separate.
That's a different matter.
That's-
The reason to
Because
take,
either then, if we have to
Then
apply,
I go back to my-
facts have to be brought.
when I go back to my first submission, 3 judgments of your lordship's court, that I can sustain the conclusion by reasons, and more so on a question of law. My lords have always, forget anything else.
This is a big question.
In fact,
of fact
Justice
and law.
Lahote has gone to the extent of saying, even if a point has been decided against you, and you don't file an appeal, but the overall judgment is in your favor, in the appeal, you can canvass that point.
Sundram,
Well, I'll show your lordship the judgment. Let me
Sundram,
deal with that separately.
but 290 requires a factual basis.
My lord, I'm on a different issue. 290 does not require a factual basis. The proviso requires a factual basis, not the section.
No, that it has to be read as a-
No, my lords know that
Not-
onus of proof for the section is me.
relies based upon by you, then yes.
Then I'll show it to your lordships now. I'll show it to your lordships now.
We will not permit you to.
My
read
lord,
that off.
please don't say that. I'll explain why I'm saying that. I'll explain why I'm saying it.
290 doesn't apply, Lord, on its plain language. Lord,
I'm sure you'll
There
answer
are-
me, Dhruv.
there
I
are
have a lot,
decisions in
I'm
his
sure you
favor.
want to answer.
Otherwise, it will lead to huge difficulty. There are decisions in his
My lord,
favor.
290,
And
if it was
to
not
be very
there,
frank, to be very frank, also, he may be right in that, because if you look at the nature of order passed, he says you're aware of it, so therefore this discarding and relying upon the proviso when they are saying you're aware of it in a negative sense. So this says that nothing in this section shall deem to give validity to acts done of a director after appointment is shown to the company to be invalid or to have.
that was taken by the first time. Why? Not because the director was disqualified under a provision of this act, but because one party came forward and said, excuse me, I did not receive notice. Now, the first time that comes up is in the year 2013. Please, my lords, apply the proviso to its full.
Mr.
That
Pradhan,
first time,
this really is a acceptance of the principle of doctrine of indoor management
that's correct.
and not applicable when there are disputes intercede.
my lord, there were no, the point I'm saying is that would arise when, let us say the company is shown, the proviso, I'm just dealing with the proviso, that the act done by the director after his appointment has been shown to be invalid or have been terminated.
Now, let's cut out, we have understood your argument, but just examine one thing. I wish we had pointed it out to you on that day. Worst come to worst, even if we accept the appeal, only the rights issue goes. Only the rights issue will go. Right issues, they have not subscribed to those shares, correct? But even if they have not subscribed to the shares.
Give them that portion.
No, that's what, Or we strike down the rights issue. You go back to square one as the situation was. There again, you have the majority share.
I'll do something else. I have another suggestion. Same effect. The rights issue, so far as Aurora's shares and my shares are concerned, we take. The balance, what they would have been entitled to, let them subscribe and I will regurge. I will transfer those shares to them. I'm making this based on what you're saying.
That's fine.
But I will get the other portion, what I can subscribe and what Aurora's can subscribe. The balance, my lords, what they could have got, that sure, I will transfer it to them and they can pay me the pro rata.
Lord, your lordship would recall, because Mr. Sundaram opposed it. My lord, we had on this side made a submission. This is a fit case because ultimately, my lord, there has to be exit of one party. That's what normally happens, my lord.
We are going.
And that's what we had said, my lord, at the beginning.
Mr. Dhruv Mehta, please understand, what is being suggested by them may be a step in that direction.
So I
may not like to. Look, I will not force any party to enter into a settlement.
I agree. But ultimately, my lord, this is, my lord.
Or even if the right issue goes, nothing happens. Because today, if we obliterate the right issue, there may be huge consequences because money has to, disgorgement has to be done, money has to be paid back. You purchase those shares, they'll transfer it at the same price.
Lord, that I will take instruction. What I'm saying is this, my lord.
You take that instructions,
Lord,
it may be a stepping stone. It may be a stepping stone to further. Ultimately, many of these matters get.
Lord, there has to be a global settlement, my lord. I'll tell you also why.
We will not force anybody to do that. Neither will we step into them, nor it's for them to decide.
Lord, if your lordships were,
my lord, that's my worry about that is, by the time that happens, by the time the valuation reports, by the time each one challenges that valuation report in the NCLT, we are talking about long time. I am concerned with today and now of giving effect now to these orders.
There are two ways to look at it. Either you talk to, if your clients are interested in settlement, then we can give it to a mediator. Mediators are not bound by the valuation reports. There are ways and means by which they can do it.
Since it's fallen from my lords, yes, but in the meantime,
I'm not asking you to go for me.
No.
I'm not asking you to.
Not in mediation at all. Please, my lords, I don't know.
Neither am I asking you to please settle.
I'd rather have my lords decide it here. But my lords, in the meantime,
we will not cross that line.
But in the meantime, my lord, let not that transfer of the shares of 9,040 shares or this balance rights issue, whatever, be affected in any way. Because what happened?
No, we are not deciding.
Your lordship, I'll explain why what happened, and because that's a third matter. In execution, they did not give effect to this order. In execution, I wanted, my lords, that those transfers to be made. Now, just 1 minute, please. What happens, my lords, is that's in the other connected case which has happened. 1 minute, 1 minute.
Execution order is not in this matter.
In the 1 minute, in that also they did not comply with that order. What happened was we moved for execution. Execution was directed by the court. When they moved the matter before your lordships said, I'm not passing an order, but Mr. Sundaram, please tell your clients to hold their hands. That I want to ask my lords, that please, so far as this 9,040 shares are concerned, let's give effect to that so that the company can go on. Today, we can't be every meeting. No, those 9,040 shares are not yours. This is not yours. Let me go ahead with the running of the company on that basis.
Because that's going to affect me.
In other words, he wants a stay of the entire thing till then. Malad, that would be impractical, is what I'm saying.
It was oscillating.
Innocuous looking statement made.
Mr. Balbir Singh, wait, let him make it.
Auroras are not oscillating at all. In fact, the transfer is completed. Our Auroras have given it, they've given affidavits before your lordship's court. They've given affidavits. They are not oscillating. They are, my lords, because they got what they wanted at that time. They did it.
Before this.
1 minute, Mr. Mehta, please. Look, how is it affecting the day-to-day working?
I'll explain, my lord. My lord, with that 9,040 shares, at least we have a majority. Forget the rights issue. My lords are saying that. It can't be today we are again in this impasse.
No, look, if there is a talk of settlement, we need not modify any interim order. We give you a month's time.
There's no interim order at all, your lordship.
We're not saying anything like that. You take about month's time. If you can sort it out, fine. If you can't sort it out, we'll decide legally. We're not going to be affected which party backs out. That's irrelevant for us. A decision on merits will not be governed by even an unreasonable stand taken by a party, that's not relevant.
Madam, may I make one suggestion? Don't give them 1 month. I'm just saying it from me. Madam, give them 10 days, not more. Please do this. I'll explain why, my lords, because by then a whole lot of other influences start coming into play. Let the parties sit and let them decide 10 days if it can be done. Please list it after that.
It will be too short.
My lord, otherwise nothing will happen because over the years nothing has happened.
We give them 15 days.
Just
There are two ways to look at it. I have known of litigations which had been pending for 20, 25 years, which got settled after about 6 months of talk.
Unless
6 to 7 months of.
Then can I make one suggestion?
But sometimes you may be right. It may, because if the time is right, it may happen in 10, 15 days. Also.
May I make one suggestion then? Your lordships have heard me on the matter as to what your lordships also said, give us.
Look, ultimately, even if their appeal is allowed, nothing is going to change on the ground. Let's assume their appeal is allowed. Assuming if we don't accept, reject all, nothing on the ground changes. Nothing on the ground changes.
My lords, I'm happy to. My lords, I'm happy to conclude now and await your lordship's judgment in the matter. I'm ready. My lords, I have shot my bolt. I had some case law to place before my lord. That's all. But to support the propositions I was raising, including on 290 and including otherwise, I was going to just place that case law before my lord on the transfer of property. But 9,040 shares. So far as rights issue,
nothing on the ground changes because Auroras are with you. You have the majority.
Well, that's where now let's kindly allow me just 2 minutes, Wallace.
And the new board is there, everything is there. That's
The
true.
decision of this.
No, they're not.
The decision of the board of the company in question
parties a chance to say.
Instigated the petition, operation and mismanagement against the company, which in a settlement was to come to us. Where this order was passed on one particular transfer of shares, which give them a majority of no
This
majority.
is what I'm concerned
Finally,
about.
Let him have his
at least
5
let me
minutes
say
of
that.
word. That's it.
So the innocuous looking statement to say that the board is going to do what has not been done. One thing in Mr. Sundaram's first proposal is that the board, I agree, may not be constituted rightly, or a defective board, I may call it. Certain decision taken by the board.
Mr. Singh, why are you going on the legal issue? We are not even touched.
So I offered on the day one. We offered before the NCLT 2 orders
We are not
passed.
going to decide who gets what or what they are entitled to.
So
that's for you and him to
I
decide.
have no difficulty. Fortunately, it's because the jurisdiction is an equitable and a fair jurisdiction. We
Look,
right from the
that's
beginning.
That will happen. Look, there are 2 aspects. As far as the second case is concerned, we have not even touched upon it. As of now.
Yes.
We give you 15 days time. Please nominate or name a mediator if you can both agree. You tell us at 2 o'clock.
We request whatever the court appoint, we are acceptable to us.
We leave it to your lordships.
Because ultimately,
to your lordships.
if the effort is genuine, I don't think Mr. Sundaram will object to it. If the effort is genuine.
Yes, we leave it to your lordships, my lord.
If you're very serious about it, we can trouble a retired judge of this court.
We are absolutely bow down,
Then, my lord, I'm giving my lords 3 names straight away. I think neither of us will object.
You can have justice call also.
I'm giving 3 names. I'm sure they'll agree to any 3. Justice Kaul, Justice Sikri, Justice Sen. Any of the 3.
Leave it to your lordships, my lord. I'm sure. Objection. As I said, my lord, we leave it to your lordships.
I will have no problem.
Right on. Without prejudice to rights and contentions of the party, then it comes for the council summit. That matter may be referred to mediation. Be undertaken by Mr. Justice, given back his retired Rajikishan Paul. First up, in view of the statement made, we request So Justice, given back his retired Sanjay Court, take up the issue, the intercede disputes for consideration and resolution through mediation. Stop. Parties will approach the mediator within a period of 2 days, within a period of 2 days from today. Mediation will be, we have, the learned mediator, learned mediator will be entitled to charge the fee as per the fourth schedule. Fourth schedule? Yes. That will be a fourth schedule.
Lordship.
Okay, I will not refer anything about the fee.
Yes, my lord. Lordship will leave it.
But whatever is to be decided should be decided mutually. It should be with
Yes, my lord.
consent of the
Yes,
governor.
I don't think there will be quibbling.
Relist after 4 weeks. I'm going to relist after 3 weeks.
3 weeks.
Very well.
Lordship,
My lords, both the
indicate
matters.
a date.
Both matters.
Your lordship like to indicate a date, my lord.
There's a reason why I'm not doing it, but I'm going to now, probably whenever we say after 3 weeks or 4 weeks, it means it must be listed within 10 working days thereafter.
My lords.
Because otherwise it it's an
Goes,
open-ended.
it just goes into cold storage.
That's right.
That's probably may solve the problem. It should be listed with, it gives enough leeway to the registry also to find a suitable date. At the same time, it doesn't leave it open-ended. Maybe not 10 days, and depending upon what the registry tells us, maybe 15 days. So 10, 15 days within.
That's very reasonable, Manoj.
That will sort out a lot of problems.
It will, my lord. Once
Yes.
that happens.
Lordship. Grateful, Manoj.
Lordship.
Deeply obliged.
I appear for the appellant. Sorry. It's the appellant before my lords was a plaintiff in a suit for specific performance. The suit came to be decreed, my lords, by the learned trial.
Learned argue the matter of merits. Today he has moved the application seeking stay. And
No, please, we'll go on the merits. We'll go on the merits. That's not the way it is. We'll go on.
What I'm saying, only
No, please start.
Yes.
We'll not adjourn.
Yes.
The appellant, my lords, was the plaintiff in a suit for specific performance. The suit came to be decreed. The decree has been partly set aside by the Honorable High Court, my lords. The reasoning I would submit is erroneous at page 11 and 12. My lords, 3-4 dates my lords may just have. The agreement to sell is dated 22/5/1992. That agreement had certain conditions precedent. The first of those
agreement?
22/5/1992. The land was measuring about 3 guntas. The exact measurement was not known, so it was said that 84,000 per gunta would be the sale consideration, which is to be measured. There were certain conditions precedent. Sorry.
So that was, sale consideration was 84,000 per gunta.
Per gunta.
How much advance did you pay?
29,000. 20,900. Sorry. 20,900. 100. I'm sorry. 20,100. Let's stop it. Thereafter, my lords, there were 2 conditions precedent in the agreement, after which the sale deed was to be executed. The first condition precedent is satisfied on 3/5/1995.
What were the 3 conditions?
2 conditions. One is, my lords, that the defendant is to obtain a layout of the land sanctioned by the Commissioner of Urban Development Authority. That was the first condition.
Layout of the land?
Sanctioned by the Commissioner of the Urban Development Authority. The second was to obtain permission of the Deputy Commissioner under the Urban Land Ceiling Act. That condition, my lords, no longer holds good because the act has been repealed thereafter. So essentially, it was the first condition.
No, but layout of the land is something very.
That's right. So he does it in 1995. I immediately issue a notice to him.
The one where it is.
Yes.
So that's also something which is really not relevant. But we are talking about the condition as it was existing then.
As it was.
Urban Land Ceiling Act condition is required.
That's right.
It was an urban land?
It was an urban.
The Urban Land Ceiling Act, the condition was required to be satisfied.
No, but thereafter the act has been repealed.
Maybe not.
At that point of time.
At
that's
that
right.
time, it was required.
That's right.
Yes. The first condition is really not a condition as such.
No, all that the agreement said is that after he completes this, thereafter he will tell me and the sale deed will be
How much
executed
amount did
within
you
my-
pay?
But nothing was done on
84,000 into 3 means something like
2 lakh, 2.5 lakhs.
2.5 lakhs. You had paid only not even 10%.
That's right. I'll just give me just 2 minutes. Let's 2 more dates I'll show and then I'll come to the reasoning of the trial. On 3/5/1995, the first condition is satisfied. Therefore, I immediately issue a notice to the respondent on 24/6/1996, to which the
24? When did he get the permission to the Rabbi's land?
3/5/1995.
3/5/1995.
I issue a notice on 24/6/1996 after, according to me, repeatedly requesting him, which is not denied by them.
Yes.
Which was replied on 14/9/1996, where he admits this agreement, admits the agreement, admits the advance payment. Now, my lords, I'll straight away come to the averment in the suit. In my suit, I specifically take a contention. Please have page 29. Twenty-nine is the plaint, and my lords may straight away have page 32, para 5. Let's have page 32, para 5.
Yes.
I'll just read that one para. Plaintiff is ready and willing to perform her part of the contract. Plaintiff is ready and willing to pay the balance sale consideration. Plaintiff has kept ready the balance consideration amount to pay the defendant. Plaintiff has requested the defendant to obtain the necessary documents from the concerned authorities. In the first week of June 1996, plaintiff personally approached the defendant and requested to file an application in the office of the competent authority, but the defendant did not show interest. Therefore, plaintiff issued legal notice dated 24/6/1996 and requested to prepare the necessary documents and to obtain the permission. Plaintiff has further brought to the notice of the defendant her readiness and willingness to pay the sale consideration. Now, please see the response to this in the written statement, which is at page 36. Their first defense, which they take, is at page 38, para 3 and 4, where they admit the execution of the agreement. Page 38, it starts at page 36 at 38.
Yes.
Para 3 and 4. They admit the execution of the agreement, but say that your husband was the one who was negotiating with me. Therefore, the agreement is in effect with your husband. This has been disbelieved by both courts. Their second defense is para 6.
Yes.
Even if the plaintiff opts for 3 guntas, the remaining area of half gunta will be without any use. It will be completely useless. It is therefore submitted that in view of the same, the defendant will be put to great and irreparable injury. This also has been negated.
Yes.
Then, my lords, may turn over page 40, para 8.
Yes.
Now, this is what, my lords, is relevant. About middle of para 8, the line starting with thereafter, my lords.
Yes.
Thereafter, this defendant approached the husband of the plaintiff many times personally and requested him to give the signature in this regard. The defendant also enlightened on those visits about the suit agreement of sale and requested the husband of the plaintiff to cooperate and get through the said transaction completed. The defendant many times requested the husband of the plaintiff him to cooperate and get transaction completed. Even after 3/5/1995, the defendant went every day to the house of the plaintiff and requested the husband of the plaintiff.
So he's saying that you are not ready.
That's right. And this has been disbelieved by both courts on the basis that my signature was never required for this purpose. There is nothing else stated. Now, my lords, please see, nothing else is stated as far as the readiness willingness. Please see how the High Court sets aside. Please see how the High Court partly sets aside. Specific relief is granted in respect of 1 gunta in my favor on payment of about 2 lakhs more. But please see how the rest of it is set aside. Kindly have page 11, para 23.
Uh, maybe the written statement is not very articulately drafted.
Yes.
The agreement to sell, you just paid 10% of the amount. Even otherwise, we have the discretion not whether to grant you in facts and circumstances of the case. Justice Bela Trivedi's judgment, to which I am also a party, sets out those circumstances. Why should we at all interfere in a matter?
Today, Maloj, 1 gunta has already been specifically granted in
1992,
respect
you
of.
paid 10%, you put the clock, you set the everything on hold after that.
What? No, I'm so sorry, Maloj. I have that, in respect of that 1 gunta, I have deposited the amount with the court.
He's not filed cross appeal. Have
He
you
has
filed?
he has not filed a cross appeal. So there,
happy-
there is no question on that 1 gunta. And he has sold it. In fact, we brought it to your lordship's notice. My lords were kind enough to protect us. When the matter is pending here.
Look, if we confirm the degree as it is, whatever consequences are there is there.
I would request your lordships to set aside this judgment and confirm
No.
the trial court's
No,
judgment.
by paying 10%, we'll never.
Please
By
give me just 2 minutes.
That too of 1992, it will be highly unjust.
Would my lords then consider, if some money is to be paid extra?
No, please, not at all.
Otherwise, this woman
No,
who has
please.
entered into the
In
agreement
2002, your suit was decreed. You are required to deposit the balance amount.
No, I was
You
not.
don't do that.
I was not. In fact, there the High Court is wrong. They were supposed to measure the land, and I have.
The trial court decree.
Please have the decree, my lords. I'm grateful. Please have the decree.
Please, look, let's be very clear. 1992.
Yes.
Till 1996, you don't file the suit 4 years down the line. Yes, they had to make certain compliances. All that they said, written statement is not well drafted. I can say that.
The specific contention, just give me 1 minute. The specific contention in the written statement has been negated by both courts. It is not that it is a loosely drafted written statement.
Sorry, we are not inclined to interfere with the impugned judgment and hence specially petition is dismissed. Next case.
It's an appeal. Sir.
Appeal. We do not find a good ground and reason to interfere with the impugned judgment and hence the appeal is dismissed.
Grateful.
Why were you taking adjournment?
Just I have seen a matter listed just.
What is this?
Only for hearing on the application for history, the matter listed.
What is this?
They started making some merit. That's
No, please,
nothing
don't
more,
do
please.
that. Don't do that.
Sorry.
This is our application for vacating interim order. Should the main matter arises out of.
No, we'll hear the main matter. We're not restricting it to the application. We'll not restrict it to the application. We're making it clear.
Lordship may hear the main matter. We'll conduct.
Please do.
Please, Your Lordship. Lordship,
Mate. Sir. I'm here. I got this. My lord's last order is dated 19th May 23. 19th May 23, your lordship, sir.
What is the issue?
My lords, the issue here is the lady concerned, she's an elderly lady whose husband was a 22.5% shareholder in a company. Company has one and only one asset, which was this land in Jamnagar. My lords, her husband is currently no more. At the given time, he was in America for a heart ailment treatment. But suffice it to say,
you are 22.5% shareholder.
22.5. The board decided to sell this property comprising of, my lords, 5,701 square meters in Jamnagar.
7,000?
5,701 square meters. And other than this, the company has no other asset. In other words, it's the whole company is being sold. There's nothing left. For a total consideration of 6 crores, we produced a valuation subsequently of the same period for 70 crores. But leave that may be, my lords. This property was sold on the guideline government 11. It was sold in 2020. At the government guideline value of 2011, there was no advertisement, no call for offers, nothing at all. The property is brought to sale and sold. Today, they claim in their counter that they had a board meeting on 23rd March 2019. We accessed the portal of board meetings for the year. There was no board meeting on that date. On the contrary, they had given me notice, my husband, of notice of a board meeting 5 days before it, or 6 days. He responded saying, please don't have this meeting because I'm in the United States with my treatment. I cannot be there. Now, my lords, they claim this board meeting in their counter before your lordships. That I have, my lords, on here the portal which shows their own entry, which shows board meetings for the year. There's no board meeting. My basic, sorry.
What petition had you filed? You had filed a petition?
I'd filed, my lords, a 241, 242.
241, Operation
240 on that. And pending that petition, an interim order came to be passed of status quo with regard to the construction. The purchaser purchased the property, and a status quo with regard to X number of units to safeguard my interests. My lords, the NCLAT reversed the order of status quo, saying, no, there's another purchaser, it's a third party interest, etc. Your lordships passed this interim order, and I'm saying this interim order subserves our party's interests. And in fact, the matter can be directed to be heard and disposed of straight away. If I can just read my lord's order.
He said 40%. 40 units.
Yes.
40 units will not be sold.
Your lordship said 40, although our 22%, the total units are 302. And I said 302, 22% number of units. Your lordship said, no, don't do that because that will be unfair. I'm just recalling. Lordship said some units may be double units, some may be single. If I say number of units, it might be difficult for them to sell. So let us take your 22% of a total area, 1,46,000. Your area is 30,000. So I will say 30,000. And the other side was to say how many units could 30,000, for example, larger units, and therefore reduce the units to 40. But the total area is 30,000. My lords, I believe this would be an equitable order because on the one hand, NCLT had said status quo as to further construction and do not sell any of the units. NCLT went the other extreme and said, I'm vacating all interim orders. Your lordships have passed this order by which they can continue, but just keep aside this 30,000. I believe, my lords, this subserves the purpose of justice in this case, and the NCLT can hear this matter. But on the face of it, my lords, 6 crores for 5,700 square meters of land in 2020, where the land value is 1,22,000 a square meter, has been sold for 6 crores. My lords, then it's near the Reliance factory, refinery. My lords, I'm even making a suggestion. To be fair to my learned friend, I have not made the suggestion. If this can even be done, instead of, my lords, a valuation or something, this 30,000 square feet can be given to me in full and final. I've told them to accept it and leave it. So that also, because that also comprises 22%. I said, in that case, don't go into value, don't go into it.
I represent the purchaser.
No, we are not concerned with the purchaser.
No.
Look, if the allegation is that the company which has sold is undervalued and they have taken benefit, so the actual file fall on you also.
I would.
Fall on you also.
The action is about operation and mismanagement. The only allegation is that the valuation is not, the consideration is not commensurate to the valuation. This allegation is made on the basis of one valuation report, which I would be able to satisfy on the face of it.
Is it a matter of fact that the sale deed is executed on the basis of the circle rate prevailing in 2010?
It is at a valuation more than double of the circle rate.
Double is also less.
The circle rate.
When was the sale made?
Sale was made on 13th of July 2020. This petition is filed.
And what is the amount fixed?
The amount is at 10,500 per square meter. The circle
Very
rate
low, 10,000 square meter.
is 10,500 per square meter. The circle rate is 4,500. What they are saying, and
Let it be,
just one thing.
let this order continue. What the other option is?
I'll just find out, sir. Just one thing. Lordship, the grievance is with respect to the company. I have already paid 6 crores to the company for the reasons best known.
Please, that will not be relevant because you are dealing with a company, and when you are dealing with a company and the allegations made that underhand money must have been paid.
There is no allegations.
That's the allegation.
They are not saying that.
That's the allegation.
There is not a whisper about it.
No, that's very clear to us. Why are you hiding from that?
Sir, they are not even alleging that.
No, that's what we have understood.
So what
else is their allegation?
Alleging.
No, they're alleging that. Please do not hide. Please do not say they're not alleging. They're alleging it very plainly and openly.
May I say like this, sir? Our sale deed is of 13th July 2020. This petition is filed after 2.5 years. And the first order was passed in January.
Maybe. We have to look at the...
One more thing, sir. It was an open piece of... This was, the company had a...
10,000 rupees in any town or cities. Nothing.
First, sir.
Okay, are you ready and willing to pay them back? Sell them back? We'll ask them to pay for 5 times that amount.
Constructed 302 commercial
units. They'll pay you for that. We pay them. They'll pay you 5 times the amount they have paid.
It's 2 minutes. I will not take much of your lordship's time. Lordship, this sale deed after...
Look, today we are in 2024. It's just 4 years down the line. Okay? They'll pay you 3 times the amount you paid for the land plus the cost of construction.
Sir, may I say, sir, 2.5 years, this company had a single screen cinema, which was closed for 15 years. The company demolished it and sold me the open land. I constructed this massive construction.
Yeah, we are with you. We are with you. All that we are saying, you take it. What will they pay you is 3 times the price you have paid.
Lordship, the
1 minute fees and the construction cost. You take the 3 times the price.
Too much, I will just say. They waited. This whole building came up. They allowed it to come up. They came up after the building was constructed.
Please take it. Please take it. One, your contention that they are not challenging that their property has been undervalued. Property has been undervalued so that to get some extra benefit to the people who are in control and charge of the company. 1 minute. There are various ways to deal with it. One is we confirm the interim order, or number 2 is you give them a small portion of it and let them take that money, whatever it is.
May I just make one suggestion like this? What my learned friend said, let the NCLT hear it. This is against interim order, fair enough. NCLT needs to hear it, where I will be able to make all the submissions with respect to valuation, etc. So far as my keeping aside the units is concerned, I have filed an affidavit where I have identified 48 units, totaling up to 30,000 square feet as per your lordship's order of 19th of May. My request is, sir, that I have added lot of value. This is a constructed cost. The land which I have purchased is 61,000 square feet. The construction is about 150,000 square feet. The circle rate is 4,500. Even if it is held to be 10 times that, the valuation of the land will come to 25 crore.
How much are you selling it for?
Lordship, so many units are sold.
I'm asking you, how much are you selling? What is the cost of each unit you have calculated?
That is something.
Please tell us. No. You would have quantified your per square feet area. The quantification must have been done by you.
It would have happened, sir.
How have you calculated?
Sir, it would be as per the market rate. It would definitely be higher than the prevailing circle rate.
Correct. Obviously, but tell us what is the rate you have calculated.
We will find out, sir.
Just tell us just now.
Sir, I will have to take instructions.
Just please take the instructions.
In the meanwhile, what I'm suggesting is let NCLT decide the units which are kept aside, if that can be suitably reduced so that we recover our cost. That is this.
Look, please. Look what we have done. How much area have you constructed?
Sir, I have constructed about 160,000 square.
Out of that 160,000 square feet, we have only said 30,000 square feet.
146,496 is what I have constructed.
So out of that, we have only put the restraint order on 30,000
square feet.
We have not put the restraint order on the other.
No.
So
Lordship has
1 lakh
Commensurate
45, 1 minute please. That will be 22% of the constructed area.
That's what her claim is.
You may have a point that should be reduced because it includes the
Correct.
cost of
It's the
construction.
cost of construction. So my request is let that be suitably reduced.
That
and
you
we
can
will
reduce.
argue it out
That there you have a point. You
I
can
do-
suitably reduce it.
I do not ask for anything.
I put to my learned friend, if it finds favor with my lords. I asked my learned friend to give me, with proper audited details, the actual cost of the construction. Let that be to my account. No, I'm saying, and then the area they can give me is that much less with the cost of construction.
We are not deciding.
To finally decide. No,
Not
I was only
deciding
giving
the
this,
fee.
my lords,
Not
I was
deciding
giving
the
this a suggestion to finally conclude the whole matter.
The other way is, because what we have done is we have taken the thumb rule, 22.5%.
Absolutely.
And 22.5% of the total constructed area. That was an easy order to pass, so we passed that.
That was the basis.
But that can be suitably reduced because today the cost which is there, the constructed area is there, includes a cost of construction.
Please.
We can
I'm saying we
reduce
can conclude the matter with that. We didn't go further. I'll put it to them to pay for the cost of construction. No, my lords, I'm saying I'll put it to them to pay for the cost of construction.
They will not agree
Of that.
with that. They will not agree.
Too complicated an exercise.
It's
I will
not
leave it to the honorable
complicated.
court.
We can reduce the area, we can, look, the cost of construction will be anywhere, say, a condition complex.
No, it would not be.
The cost of construction would be about 2,500, maximum 2,500 rupees a square feet. No, not more than that, not more.
Not that much also, my lord, because this is just, I understand, just units. It's not even a.
It's not a full, it's not a shopping
Not
mall.
furnished, not this, no, just construction. Construction.
The photographs.
No.
Lordship may look at the photographs. I have put up photographs. With my counter at annexure R6, page 133 are the photographs.
It's them back, the cost of land and the cost of. What they have paid. And cost of construction. I say,
Yes.
listen, who's giving me instructions here? Put a suggestion to them. I think we could sort this.
Sir,
I've said pro rata cost of the land. My lord, what I'm saying is.
15%, let it, whatever your lordship feels, 15%, 12%, let it be reduced.
My lord,
like
instead
that.
of,
Because
may I
otherwise
make a
it will be
suggestion?
difficult.
My lord, they paid just 1 minute. They paid 6 crores for the land, 22% pro rata for the undivided share, cost of land, plus 30,000 square foot cost of construction. I've suggested to them to make that as a suggestion. My lords, because they paid 6 crores. So 22% of 6 crores, because undivided, they get back the undivided share in the land, because when they get
You're
it.
arguing against your interest.
I am, but I just want to close it, because my lord, this lady is not, she's very aged and she's not going to be able to sustain. She's not going to sustain a long litigation. I know that.
Happened between the two of them. I'm unnecessarily killed actually in the.
No, you will be, because what you did also is wrong by paying under.
I purchased a clean piece of land.
No, but I agree with you. You must have paid the market value. There's no doubt about it. You paid the market.
Even if it is higher, how much higher it can be? He is asking for 20.
1 lakh, my lords, today I will get
It is the
Jamnagar.
valuation report. I will.
No. What he's asking today is very simple.
Sir, that is.
He says what he's saying because the lady is probably old and she requires money. What he's saying is this. He's saying is this. Just restrict it to the what 6 crores which you paid, divided into 22.5%, cost of construction into 22.5%, that's all. When we take the cost of construction, say it's 1,800 rupees a square feet, looking at the photographs, it must be between anything between 12 to 1,800.
Sir,
The maximum figure will be 1,800, not more than that.
so my request would be it will require a lot of exercise to be
No,
done.
no,
We
it will be
will-
done
My
too
request would be today, reduce that amount, 30,000, reduce it to a figure which I leave it to the honorable court.
Make it 20,000.
Out before CLT.
My lords, I'm not,
You want to get it clean, you want
I
to
want
go.
it clean, my lords. If they're not making it clean, then let your lordships order stand and we'll go fight it.
30,000 maybe little higher, 30,000 to that extent maybe little higher.
My lord, this is a bare shell, my lord. My lord, it's unfinished, sorry.
Then it will be.
Please, sir.
You can reduce it to 25,000, let it be.
Please, sir.
Makes no difference because he has spent some money on the cost of construction.
I wanted to finish it.
Are you ready to pay up? The other side is ready to pay up. No, they are sitting pretty.
Yes.
Because they have received the money, they will not pay.
Something and not me.
How old is she? 85? Not 80. No. I'm sorry, my lord. They did the same thing in Ahmedabad, tried to do the same thing in Ahmedabad, then they arrived at a settlement for Ahmedabad.
Wants to put an end, I think, my lord, that's why I was called. Trying to tell your lordship three things. One, my lord, 3 years, nothing done. The bar.
If you're arguing, it's different. I thought you're settling.
Beyond 3 months, you cannot go.
No, that's not right. That's not right. No, that's not right.
When I say 242 says you cannot go beyond 3 months, he's not even given a single reason why he did not for 3 years.
Anyway, we reduce it to 25,000. But if you want to sell it out, they will not come forward. Then let me put it, they will never come forward. Because they have received the money and you have parted with good money for them. But unfortunately, did it under the table, so therefore you are in a problem.
Lordship may direct them also to deposit something.
They will not. They will never agree. You are the one who is in a problem.
One and my reputation, it's not just about money.
Fine, that's fine. We reduce it just 25,000.
Please.
25,000.
Right now, having heard task for the parties and looking at the nature of disputes into C, we
I will just.
will confirm the interim order passed by this court on 19th of May 2023 with one modification that the respondent shall not encumber, alienate, part with possession, create third-party rights, enter into agreement to sell or sell except except existing mortgage with the bank to the extent of 40 units, to the extent of units with minimum actual covered area of 25,000 square feet. So stop. We have removed we have reduced the area, covered area from 30,000 square feet to 25,000 square feet. And we have also removed the number of units from 40. And we have not specified the number of units. However, the actual minimum actual covered area which can be used for shops and offices should be not less than 25,000 square feet. The areas which will be governed by the said order will be demarcated on a plan, layout plan, and it will be demarcated on a engineering, they will be demarcated in the architectural plan and submitted before the
NCLT,
National Company Law Tribunal. Full stop. It will be also affidavit in terms of the order passed by us today. Demarcating the area will be also filed along with the architectural plan.
My lords, my only request is a covered area.
That the interim order passed today would not be read as expression of opinion on the merits of it.
And if your lordship can fix a timeline for deciding, so that lordship can,
Well, it's,
that will go a long way.
Only request, would your lordship change it to?
2.5 years.
Your lordship said covered area, would your lordship say carpet area? Because otherwise this.
Okay, carpet.
Carpet.
Covered area.
My
Should
lord.
be carpeted. It should be carpeted.
Carpet.
As defined under the
Lordship,
real
there would
estate
be-
regulation. Act.
Lordship, it will go much higher in that case. It
No,
will go
no.
much higher because
What else
what
was
is
it?
sold, what is available is what is sold. Because what is sold is carpet plus something. So let it be what is sold. Super
Becomes
built-
even smaller.
The word which we use is super built up. This will be.
Well, it's super built up, I don't know, they'll put anything for super built up.
Okay, 1 minute. Instead of 25, make it 22,000 actual carpet area.
My lord.
Please, Your Lordship.
My lord, that is 10% is very high, my lord. On carpet, nobody.
No, no, 10% is, you're not appearing for the builders. They normally take in much more.
Can your lordship increase it slightly, my lord?
Not 22,000 will be sufficient. Actual carpet area 22,000 in real term because it excludes the walls also.
Yes, all right.
It excludes the walls also, it will be much more.
I leave it.
Actual carpet area means the actual, the area
Internal.
which you get, excluding the walls, etc. So, and there'll be